Oh, I'm sorry. I did
Go get him, Tiger. Oh, boy. Hello, everyone. Welcome. So if you're in the right room, we are going to be hearing from Mr. Matthew Villmer for Event Contract Essentials in the COVID era. So a little bit about Matt. He is the managing partner of the Weaver, Bennett, and Bland law firm in Charlotte, North Carolina. He began representing wedding and event partners, photographers, venues, bars, and restaurants after the BP oil spill, where he was one of the first attorneys to sue the oil company for his client's business's losses. Matt then began drafting contracts for his clients, and he has represented hundreds of businesses in the wedding and event planning industries. Matt was previously a speaker at the 2015, 2016, and 2017 NACE Experience conferences, and he's back to talk about how your contracts need to change in the time of COVID. Welcome, Matt. Thank you for being here.
Yeah. Well, hey, everybody. Good afternoon. Hey. All right, so today, let me give you a quick recap of what we're going to talk about before we do it. So first off, benefits of a client contract. We're going to go over that in general. If you don't already, bless you, if you don't already have a contract, you certainly need one. And so today, at the very end, what you'll be able to do is copy and paste, at very least, a decent amount of these clauses that I give you and incorporate those into the contract that you already have, right? So don't feel like you need to furiously write all this stuff down. I think they've given you a copy of the presentation. If not, just come and talk to me and I can send you a copy, okay? All right, cool. Next, we'll take a quick detour into business entities and why you need a business entity in particular. Then we're going to talk about how to organize your client contracts in general. Then we're going to give you, I think there's maybe 12 or 15 contract clauses that y'all can use. And then at the end, Q&A, so you can tell me all your horror stories about people not paying you and what you should do about it. That sounds great. So, learning objectives. So first, we're going to talk about some terms that you can use in your own particular contract. We're especially going to talk about these COVID clauses. So there are a lot of clauses nowadays in light of COVID, and you know, it's kind of strange. I thought COVID was behind us and we had all these clauses, but we weren't going to worry about it, but now we're all masked up in Vegas, which is kind of surreal. So anyway, pretty prescient, I think, to right now. And then finally, we're going to talk about these kind of weird anti-defamation clauses that you can put in your contracts to keep people from leaving nasty online reviews for your business. So, without further ado, who the heck am I? So I've been practicing for about 13 years, both in Charlotte, North Carolina. I practiced in New York for a long time, and then down in Pensacola, Florida. I've represented literally hundreds and hundreds of businesses that are in y'all's industry. So DJs, videographers, photographers, wedding planners, event planners, venue owners, bars, restaurants, all that. So I've pretty much seen everything. I've drafted, thousands of contracts, and I've sued over a lot of those contracts or defended against lawsuits related to those contracts, so that's me. Okay, so first, without further ado, the benefits of a client contract to begin with. So obviously you should have a client contract, right? Without one, it's he said, she said. So you'll never ever know how much you're going to get paid because your client will say, well, you were going to do all these things for me, you promised all these things, and I never really promised to pay you. I'm sure that's what they're going to say. Nothing outlines your obligations to your client without a client contract, but the most importantly, nothing outlines your client's obligations to you if you don't have a contract. So the biggest kind of thing that I see, the mistake that I see people make when they draft their own contracts, is you'll want to put in a contract all of these things that you're going to do for your clients, right? Because you're super excited, you're going to do all these awesome things for them, you want to use the client contract as a sales tool and say, look at all these things that I'm going to do for you. That is the exact opposite way you should structure your contract from reality, okay? So your contract should have all of the things that your client is going to do, namely pay you, right? That should be in your contract, okay? You'll have, yes, a list of the things that you're going to do, but it shouldn't focus on that. The focus should be, what is your client going to do, and what escape hatches do you have to get out of your contract, right? If you don't want to do it anymore, okay? All right, cool. Next, obviously a contract protects you from insane clients that you don't necessarily know are insane yet. Like maybe you got a red flag or two when you start talking to them, but you realize as the event goes on, oh, this person is a certifiable crazy person. I don't want to do this anymore, right? So that's what a contract is for, because you could get somebody like this.
I'm getting married March 8th in Long Island. My wedding is costing about $140,000, $150,000. It keeps going up, but my daddy's paying for it and I'm a daddy's girl. So this wedding's gonna be expensive and big and glamorous like me. It's you!
On top of her over-the-top budget and out-of-control ego, Karen has a little trouble dealing with anyone she deems beneath her, which is pretty much everyone.
Well, yeah, bitch, you can't afford it. There's nobody poor that's invited to my wedding.
It makes no type of sense. Why would you even want to talk to a human being like that?
People who are not invited to my wedding are just not important people.
Honestly, you never saw a limo? Back up.
Why waste the seat? It's a nice seat. It's decorated in satin.
Listen to me, you $9 an hour human being.
God, am I a horrible person? I'm not.
I'm not gonna feel sorry for her because she's in a wheelchair.
Listen, I am what I am. You don't like it, don't be around me. Nobody's forcing you. You're lost.
But will this diva in denial be able to keep her composure when things don't go her way?
I'll crack skulls. I'm gonna be a stunning bride.
I look like a dog.
But the process of getting to be a stunning bride, you have to make demands.
I am my wedding girl!
If I want this, this has to happen. If not, I'm grumpy.
Shut up!
And you know what happens when I'm grumpy?
I'll slap everybody in here if I have to.
The hits the fan, and then I get wrinkles. So we don't want that.
Yeah, so spoiler alert, she is a terrible person. All right, let's take just a brief detour before we get into the clauses, right? So let's talk about business entities. So if you don't already have a business entity yet, you need to get one, okay? So go out, form a business entity, hire a lawyer, go on LegalZoom, whatever, doesn't matter. Just get a legal entity formed, okay? So it protects your personal assets. That's the main purpose of it, okay? So if someone sues you over your contract, the most that they could ever get would be any assets that your company has. And if your company didn't have very much in assets, that's a shame for them, okay? That's the whole point, is to protect your personal car, your personal house, your personal bank account. So just go out and form an LLC. A simple LLC, probably just fine, okay? You don't need some corporation with a board of directors and officers. You don't need to go to Delaware and form a company that's owned by a wholly owned subsidiary trust in Nevada. Like, don't do all that stuff, right? Like, everybody that writes about that and that that's a great idea, I mean, frankly, it's not, okay? So just go out, form a single member LLC in your own state. That's just fine. That'll be okay, all right? Okay. Once it's open, walk down with all your business stuff that you got when you formed your LLC, walk down to the bank and say, I want a business bank account. They'll give you a business bank account, put some money in it. Any money you generate from your company, put it in the business bank account. Any money that you spend for your company, spend it out of the business bank account. If you want to go to Disney World or Vegas or wherever, don't spend it out of your business bank account if it's not a business expense. If you follow those rules, you're good, okay? All your personal assets, they're protected. Okay, cool. Next, so before we get into these clauses, as a general theoretical thing, how are you going to organize your contract to begin with, okay? So, your contract is going to be a client services agreement, basically. That's what it is, a CSA, okay? And it's going to say, here's all my general terms and conditions, and in paragraph 1, it's going to say, I'm going to provide you the services that are listed on attachment A, okay? So your contract is going to stay the same forever. It's not going to change. The only thing that's going to change is your attachment A with all your services, all right? So if you're a wedding planner and you have package A, B, C, and D, okay, great. Whatever client wants whatever package, you just slide that behind as attachment A and you're good to go, okay? If you are a DJ, great. You've got package A, B, C, D, E, or some custom set of services for your client. Okay, wonderful. Just slap attachment A on the top, stick it behind your contract, you're good to go. Does that make sense to everybody? Okay, cool. So attachment A is that list of services. That will change all the time for all your clients, but the contract remains the same. All right, cool. So in general, your contract should not be more than 1 to 2 pages. So don't feel like you need to go draft up this massive thing with all this legalese that's like the party of the first part hereinafter contracts with the party of the second part heretofore, all that stuff. Don't do that, right? Don't do it. And I think the secret in the industry, like why lawyers do that, is because when a lawyer drafts a contract that way, then you have to hire another lawyer to go figure out what the hell the contract means, okay? So don't fall in that trap. Just write it super simple. It doesn't need to be this big complex thing, okay? All right. Here's what we're going to talk about in general. So not the bonus clauses, but just in general. We're going to talk about your services clause, your payment clause, how you get paid, date change and cancellation, and force majeure. Those are big kind of COVID-y clauses. Waiver and release, limitation of liability. Integration, non-disparagement, jurisdiction and choice of law, and attorney's fees. And we're going to hit each one of those here in a second. I'm going to talk to you about each one in general, and then I'm going to give you an example clause so you can use that in your own contract. And no presentation by a lawyer would be complete without me saying, I am probably not a lawyer in your state, right? So I'm giving you general advice. This is not legal advice tailored to your particular state. So with that in mind, all right, back into my non-lawyer persona, sorry. So clause 1, services, okay? So this is usually my paragraph 1 right out of the gate, right? So paragraph 1 is, you're going to provide the services that are outlined in attachment A, okay? You're going to say what you do for your clients in detail on attachment A. Here's my list of services. I'm going to do this exact thing, and this exact thing, and this exact thing, right? And then you're going to describe what you don't do very, very broadly, okay? And let me show you how this kind of works. So here's the example. Planner, and again, if you're a venue or a DJ or you're a photographer, whatever you are, right? I'm just using planner in this particular instance, but you can sub that out and put your own profession in there, okay? Planner shall provide client the services outlined in attachment A, called services. Planner shall not be obligated to provide any other services to client. Planner shall solely determine the way planner performs the services and the hours worked, okay? So let's break that down. First sentence, you're going to give them what's on attachment A. Second sentence, nothing else. That's it, right? So whatever you've listed in attachment A, very, very specifically that you're going to do for this person, awesome, because that is all they get. So all this scope creep stuff, where people try to get you to do more and more stuff for no more money, right? That ain't gonna happen, okay? All right, you are going to do your job the way you feel like you should do your job, so no one else is gonna tell you how to do your job, and you get to work the hours that you want. So you don't have to work 24/7 for one particular person just because they want you to, okay? All right, awesome. So after you get through services, so we've already defined you're gonna do these services, nothing else, okay, how are you gonna get paid? So on attachment A, you're also gonna include the total contract price, okay? So, and usually on attachment A for planners, I have, you know, the wedding participants, and then the event date, the event location, the price, and here's the package, right? So I stick all that on attachment A. And so your total contract amount, that should be listed on attachment A. You're going to say how you're paid and when you're paid. And you're going to say all payments are non-refundable. All payments are non-refundable. And you might be wondering kind of in general, because most of this contract language is going to be severely skewed in your benefit, okay? And here's my thought about that. A vast majority of your clients, I would bet, do they read through your contract before they sign it? Hell no, there's no way. They just look at it and say, I'm so pumped to be getting married, and they usually sign it. And if someone goes through and redlines your contract, I would wonder whether I actually want that person as a client to begin with, right? I mean, I'm a lawyer, I got married. I just signed every contract someone presented to me, right? Even I'm not redlining contracts, okay? So just the way a contract is built is effectively to protect you, okay? And so, yes, all the clauses are going to be generally construed or skewed in your benefit. Okay, so don't be afraid of that. No one's going to read it anyway. So all payments are non-refundable. So here's an example. Client agrees that all payments made to the planner are non-refundable and that client shall pay planner as follows. Deposit of 50% when you sign the contract, the other 50% 7 days before the event. And again, whatever your payment terms are, they are. So you can change that as you see fit. The important part is that it's non-refundable once they pay it, okay? And how does that help you in the time of COVID? Well, here's what it does, right? So that particular contract clause, if someone says, well, look, I can't do my wedding anymore, or I can't do my event anymore, I want my money back, you can do one of generally 3 things, right? So thing number 1 is you can say, that is totally non-refundable, that's my money, I'm so sorry. That's it, keep the money, right? You need to live and eat too, okay? And so that's step number 1. Or step number 2, you can say, well, look, my contract, I'm so sorry, it says it's non-refundable, but look, I'm gonna be an American hero, and I'm going to give you your money back, right? Look at me and how awesome I am. You're welcome, right? So tell all your friends and your family members that you know of someone who is an amazing wedding planner, and they're very fair, and they're gonna give you your money back, right? Or give them half the money back. I don't care, right? You've got a bunch of different options here, but this at least gives you the leverage to pick whatever option you want. So your contract can say something, and you can do something else. That's fine. If you want to be fair, be fair. If you don't want to be fair, don't, okay? Your contract gives you the ability to do whatever you want. All right, cool. So date change, cancellation, huge thing in the time of COVID. So obviously, date changes result in increased costs and increased expense for you as a planner or a DJ or whatever you are, right? Event date changes for any reason should not guarantee that you're available. So if they say, I have this new date, I don't know, maybe you have another event that date, maybe you just don't want to do events on a Tuesday at 4 o'clock, right? And then finally, again, you're gonna see this throughout, no refunds. You wanna change the date? Sorry, no refunds. And again, if you wanna give them a refund, do it, but you don't have to. So here's an example. Planner may not be available to provide services on dates other than the client's event date listed on attachment A. So they listed it on attachment A, that's the date, full stop, okay? If client wishes to change the date, time, or location, they shall immediately inform you, so you know about it, right? And it's a requested change. You don't agree to it, they're just gonna tell you, I request that we change the date to this new date, okay? Next, planner may, but is not obligated to, provide services for client's new proposed event. So you have no obligation to go along with their date change at all, whatsoever, unless you want to. If planner is unavailable and no one can identify this new mutually agreeable date, all further obligations of the planner are terminated, and guess what? You get to retain the money. That's it. So I think they're gonna be highly motivated to work with you to find a date that you're available, and they probably should, okay? All right, cool. Next, force majeure. So this was probably the biggest thing that occurred as a result of COVID. And maybe you heard about it or read about it, force majeure clauses, okay? And force majeure clauses, a lot of people say, are the act of God clauses. And if you're using a contract right now that you found on Google, right? Or you Googled wedding planner contract and you cobbled together a bunch of stuff, odds are it probably has a force majeure clause in it. But it probably has a force majeure clause that is absolutely terrible for your business, okay? So force majeure clauses generally say, look, if some crazy act of God happens, no one has to perform, right? But your force majeure clause, if you just got it online, it probably says, look, if an act of God happens, no one has to perform. That means your client doesn't have to perform. That means that they don't have to pay you anything, right? So the way you need to think about this is never, ever, ever in a million years make your force majeure clause reciprocal. So it should only apply to you. It should not apply to your client, okay? And let's see how that plays out. So here's the example. Planner shall not be liable for any failure or delay in performing its obligations that are due to any of the following causes to the extent that they're beyond your control. So again, it doesn't say no party is liable. It says the planner is not liable. So it just applies to you. Does that make sense? Got it. So what are you not liable for? Acts of God, so if you don't perform because there's a nuclear bomb that's dropped, okay, fair enough, right? Accident, riots, war, terrorist acts, epidemics, pandemics, quarantines, civil commotions, breakdowns of communication, natural catastrophes, and this one's super important, governmental acts or omissions and shutdown orders, right? So it's not only a pandemic, an epidemic, disease, those types of things. It's even if that occurs, you want to specifically mention governmental shutdown orders because the government may limit what you can do, not necessarily what your clients want to do, right? Your client may say, I don't care about a governmental shutdown order, let's do this event anyway. And you want to be able to say, look, if you decide that you don't feel safe or appropriate to go do that event, you have the ability and the flexibility to do that with a one-sided force majeure clause. You can say, no way, okay? All right, so you need to be empowered to make that decision within your own right, and the client shouldn't be able to make that decision for you with some reciprocal clause. Yeah?
I have a question because this has just happened to me here recently about adding the word pandemic while we're in a pandemic.
Yeah, sure.
Like,
you should. Yeah, you definitely should. Yeah.
Because, well, he specifically wanted the word COVID.
Fine.
But,
Great, yeah. I mean, I think pandemic covers it, you know?
So,
yeah.
So the the government acts of omission or shutdown orders, we actually have a county in our state that doesn't really follow the state guidelines.
Awesome.
At least they didn't follow the state guidelines. So they were still doing weddings like full blown during the pandemic. Would that have gotten me out of having to work?
It sure would. And just for the AV's sake, can you pick up any of these questions or no? They're not picked up? They're picked up? Okay, great. Okay, and just so you know, everybody, we've got Q&A at the end, and you can hit me with any and all. Yeah, that's fine. That works. No worries. No, you're good. You're good. Okay, so anyway, force majeure, super important. Put it in your contract and make it one-sided. Cool. Awesome. All right, let's talk about a waiver and a release. So you probably have signed a waiver and a release if you went like bungee jumping in Vegas or you went to one of these like axe throwing places. I've drafted a bunch of these for like theme parks, cat cafes, I mean weird businesses. And so anyway, a waiver is basically saying, well look, this can eliminate claims before anybody ever brings them, right? A release gives you a defense if you're sued. The one thing you should generally keep in mind, and I'll give you an example of both of these, is that you can have a waiver, you can have a release. Anyone can sue you at any time for any reason, right? And so this isn't like an airtight, just no one will ever sue you, right? But it's Exhibit A, right? Like this is your Exhibit A of your defense, is that you waived all your claims, you said you weren't going to sue me, right? And your damages are limited. So let's talk about how this plays out. So client agrees that planner's maximum total liability for any claims, breaches, or damages, including breach of contract and negligence, shall be limited solely to the amount paid by client to planner. So think about that. What that does is that prevents anyone from suing you for more money than they paid you. Okay? So if they don't like the way their wedding turned out, I'm so sorry. The most you could ever get is a refund. That's it. You don't get all this other stuff. Client agrees that planner shall not be liable for any claims for punitive damages, consequential damages, emotional distress, mental anguish, right? All this stuff because people say, oh, you ruined my wedding. Well, I'm so sorry. The most you could ever get is the amount that you paid me. That's it, okay? Client specifically waives the doctrine of frustration of purpose and any similar legal argument upon which client might bring claims related to the cancellation of a client's event. So I added this to my standard planner contract about 6 or 8 months ago. So there's this weird kind of legal doctrine called frustration of purpose that says in, let's say, the time of COVID, right, you contract to get your wedding done on a particular date. You're going to show up, and because of a governmental shutdown order, you can't do the wedding, right? So no matter what the contract says, people were suing my clients and saying, give me my money back, right? Because the purpose of the contract has been frustrated because of COVID. And it's this separate kind of legal doctrine. And so this one is super important, right? And I've had several of my clients that have been sued under this kind of doctrine, frustration of purpose. And so I put it in the contract and say, they waive that argument. That's it. They can't make it, right? Specifically, if they are upset that this contract cannot be performed, they waive the application of frustration of purpose. And that's kind of hyper technical, but it's super important to put in your contract because if you get an enterprising plaintiff's lawyer that thinks they're really smart, they'll go and say, well, look, the frustration of purpose doctrine says I get my money back, and maybe they're right, maybe they're wrong, put it in there, and then you don't have to worry about it, okay? All right, cool. Limitation of liability. So this, I mean, COVID aside, obviously this should be in every single contract, and kind of in two respects. So the first one is obviously alcohol related. Right? So if you're a planner or a bartender, I mean, whatever you are, you should have an alcohol-related injury indemnification or waiver clause, okay? And then next, a general indemnification clause. That's probably the most important clause that you can have in a contract. And as a general theory, indemnification is, look, if I'm a wedding planner and I plan an event and someone gets hurt and they sue and the plaintiff's lawyer sues everybody. They sue, you know, the bride, the groom, the father-in-law, they sue me, the planner, they sue everybody, right? Indemnification says if I get sued by some third party, you, client, my client, has to come in and defend me. They have to pay for my lawyer. They have to pay any damages that I have to pay. They come in and step in my shoes and defend me, okay? So here's an example. Client acknowledges and agrees that planner is not responsible for monitoring the consumption of alcohol by client and client's guests, and client shall indemnify planner for any alcohol-related third-party claims against planner. So if someone gets drunk, they drive, they get into an accident, whoever is hurt turns around and sues everybody, including you, the planner. The client is going to step in. They're going to pay for your lawyer to defend you. And if you ultimately have to pay some money, they're going to pay that money. Okay? All right, that's indemnification. And I like one specifically for alcohol-related injuries, right? And then I do this kind of belt and suspenders approach with this second sentence. So, client shall indemnify planner for any other third-party claims against planner arising under or related to the agreement as well. Okay, so alcohol-related stuff, and also if grandma slips and falls, you're gonna take care of that too if I get sued, okay? All right. Integration. So this is a super simple clause, but it basically does more to prevent this scope creep thing, right? Because what people will say is, well, look, I know the contract says this. It says you're going to provide these services. But remember, when we first started talking, we had this side agreement. You said you were going to provide all these other services, right? Don't you remember that? And you're like, well, no, I don't remember that at all. I don't think that actually happened, right? An integration clause is what prevents those types of miscommunications from happening to begin with, okay? So, an example. This agreement represents the entire understanding between planner and client and supersedes all previous agreements, whether oral or written. So basically, the written contract is the end-all be-all. That is the sum total of our agreement. Attachment A has all the services. That's it, right? There are no side agreements, no nothing else. That is the full sum total of our agreement. The second sentence says, no change or modification to the agreement, including the scope of the services, is valid unless it's in writing and signed by you. Okay? So the only way that you can modify the contract to increase the scope of services or whatever it is if we put pen to paper and you say, I agree. Okay? All right, cool. Next, non-disparagement. And this one is super, super interesting. So at the outset, right, I know everybody's business, I mean mine included, dies and lives by online reviews. People look at the online reviews on Wedding Wire and The Knot and all that stuff, and they decide whether they want to hire you or not. So you can use a non-disparagement clause in your contract as leverage to get people to take down negative reviews or to prevent them from leaving negative reviews to begin with, okay? And a lot of people think that this is kind of a scary topic to discuss only because a lot of people think, well, you're abridging my free speech rights, right? Well, here's the thing. You, as wedding planners or whatever y'all are, you're not the government, okay? So you're not infringing upon someone's free speech. They are contracting with you and giving away their right to leave negative reviews. And they can do that. You can put that in your contract. And odds are, they're not going to read it, right? So I'll tell you, about half of my clients choose to put the non-disparagement language in their contract. About half don't. And we'll talk in a second about maybe some negative repercussions associated with these clauses. But half do, half don't. And some people feel comfortable with doing it, some people don't. So, yeah, we'll talk about the backlash here in a second. So, all right, here's an example. And we're going to break this down, okay? With the aim of ensuring fair public feedback and to prevent the publishing of defamatory content, client agrees that he or she shall not, directly or indirectly, through third parties, post any online reviews on Google, Wedding Wire, The Knot, Yelp, or any other website expressing views that negatively affect the reputation of the planner. So let's break that down, right? So they specifically say they're not going to post on all these websites things that negatively affect your reputation. And not only them, it says directly or indirectly through third parties. Because what they'll do is they'll get their sister or their grandma or their bridesmaids to go put a bunch of negative things online because they hate you, right? So it nips that in the bud. It says you can't do it and you can't get all your friends to do it either, okay? All right. If client refuses to remove offending content after receiving a request from you, you say take it down, and they say no, right? Client agrees that he or she shall immediately pay XYZ amount of money, so you pick the amount of money, as liquidated damages, which represents a fair estimate of damage done to you. Okay? So, not only can you say you can't post it, if you do post it, and I tell you to take it down, and you don't take it down, you owe me money. Right? Yeah, pretty wild, okay? So let's talk about the amount of money. So you cannot put $1 billion, okay? So you can't do that right out of the gate. You have to choose some amount of money that is reasonable. You could literally look at a judge or a jury with a straight face and say, this is how I came up with this amount, not I plucked it from the sky, right? So usually what I recommend is choose an amount of money that is the average profit that you would generate from one job, okay? So if your average wedding gets you $8,500, liquidated damages, $8,500, whatever it is. I think that's fair. I think you could look someone in the eye with a straight face and say, that's how I came up with it, they owe me that, right? So what's the purpose of all of this? The purpose of all of this is, if you get a sneaking suspicion that someone is going to leave a negative online review, you either hire a lawyer or you do it yourself. You write them a very nice letter that's very, very polite. And you say, hey, wonderful human, right? See the attached contract, which you signed, and look at section whatever, right? It's got a non-disparagement in it. Highlight it for him and say, look, I noticed that you put this online review on the wire, whatever it is, right? And I want you to take it down. And if you don't, that's what's up, okay? If you don't, that's gonna happen. You're gonna get popped with this amount of money. So just take it down. And usually, I'll tell you, for my clients that get negative reviews, when I send that letter, they take it down. That's what they do, right? They take it down most of the time, most of the time. So the negative things that could come with this is that if someone gets really, really upset, like if they're an honest-to-God maniac, then they will really get all of their friends and family to leave negative online reviews. They will probably call the local news and say, someone is abridging my free speech rights, right? This photographer is a huge jerk, and they're not letting me leave negative online reviews, and they'll do this big human interest story about how big of a jerk you are, okay? So that's the one thing to think about, and this is an example.
Silencing critics before they ever weigh in. Customer reviews carry a lot of weight, and as Paula Eben explains tonight, some businesses are using a controversial new tactic to avoid getting any negative feedback online.
As Karina planned her wedding for this summer, she decided to switch photographers.
I just kind of was uncomfortable with their lack of responses and their kind of runaround.
Like many consumers today, Karina went online to warn others of her bad experience. Then she got an email from the photographer saying, "We kindly ask that you remove your posting," noting she could face legal action for breach of contract. Karina didn't realize her contract had this clause: neither party will disparage the other.
I was livid. I was so upset that A, I couldn't review a vendor, B, that you would email me almost threateningly. So I felt like, I think I felt bullied.
Anya Winnica of TheKnot.com is seeing more wedding vendors trying to stop couples from speaking out negatively.
Prohibiting them from giving a review that's less than a 5-star review.
These clauses are now used by contractors, plumbers, and dentists. Even some online merchants are making non-disparagement clauses part of their transactions.
Companies are very protective of their online reputation, and for good reason. A Harvard Business School study found that one more star in a Yelp review can increase a company's business by 5 to 10%, and vice versa.
Attorney Noah Davis is alarmed by the growing use of these clauses and isn't sure how the courts will interpret them.
Don't sign those agreements if they don't allow you to take those clauses out of the contract.
Karina removed her online review to avoid legal headaches, but worries this trend will result in consumers not getting fair warnings.
So it's a huge game changer if you really can't speak freely about your experiences with some of these businesses.
At a time when so many want to speak out. Paula Eben, WBZ News.
Yeah, so Karina didn't realize that this was in her contract. It's like, yeah, Karina, read the contract, right? So you'd see that it was in there, okay? And so I feel like that's probably Karina's fault. But ultimately, what did she do? Well, she took down the review, right? So she took it down. But the problem is she also talked to the local news, and they loved this story, okay? Now, I mean, thank God they didn't mention the name of this photographer, but I'll tell you, they could have, and certainly that would probably do more harm than good to your business. So this is more of kind of a business decision. If you decide as a business that it makes fundamental sense for you to put a clause like this in your contract, then do it, right? And remember, you can always load up your contract with these various clauses about it being non-refundable and all these other things. You don't have to enforce these clauses if you don't want to, okay? So feel free and put it in there. If you don't actually want to send them a nastygram that says take it down, then don't send it to them. Just let them leave it up, okay? All right, cool. All right, next, jurisdiction and law. Now this is a tiny little clause that has so much importance, you have to put this in your contract. So as you probably know, events are multi-jurisdictional. So you may live in one state, you may fly to other states to go plan events or do various things like that. I mean, I live in Charlotte, North Carolina. We're literally 15 minutes away from South Carolina, and so all kinds of people go back and forth across the border doing events in both states. So every single event, well, most events have some sort of multi-jurisdictional aspect to them. And what you always want to keep in mind is that if you're going to get into a beef with your client, you want that beef to be in your own backyard, okay? So you want that dispute to be handled in courts that are right next to you in your county, whatever is the most convenient for you, and you want those disputes to be handled underneath the law of your particular state. So if you live in New York and you're planning an event that's in Phoenix and you fly out to Phoenix, you go to the event, the contract that you have the Phoenix client sign should say, this agreement is governed under New York law, and if we get into beef over this agreement, you're going to come all the way to New York to go litigate with me, right? And so again, it's a way of providing a little bit of leverage between yourself and your clients, where if you get into a dispute and ultimately you have to sue them, you sue them right there in your home state. And then they have to travel back and forth to go defend against this lawsuit. It is a massive pain, and more likely, they'll just do what you want. They'll just pay you for whatever you're asking for, okay? All right, here's an example. This agreement shall be governed by the laws of the state of XYZ, whatever your state is, and any disputes arising out of this agreement shall be adjudicated in XYZ county courts. That's it, super easy, right? It just says, if we get into a beef, you're coming to me, and it's gonna be under our state's law, okay? All right. Next, attorney's fees. So oftentimes people ask, hey, if I have to sue someone or I have to defend against a lawsuit, do I get my attorney's fees paid for? Right? So if they lose and I beat them, do they have to pay me for your time, Matt? And the answer is no. I'm so sorry, but they don't, right? And there's only two ways in general that you can get the other side to pay for your lawyer's fees. One is if there's some state law or statute that says it, or two is if your contract says it. That's the only way. Okay? So you want to make sure that your contract has a clause in it that says, you're going to pay me my lawyer's fees if I have to sue you and I win. Okay? Now, the difference between this kind of force majeure thing that we were talking about, make it one-sided, in most states, these attorney fees clauses have to be reciprocal. You have to say, the winner gets paid their lawyer's fees. You can't say, I, the planner, get paid, but if you win, client, you don't get paid any lawyer's fees. You can't do that, by and large. Okay? All right, here's an example. In the event a lawsuit is filed to enforce the terms of this agreement, planner and client agree that after judgment is entered, the losing party shall reimburse the winning party all the winning party's attorney's fees, costs, including attorney's fees and costs spent pre-trial, trial, and through appeal. Okay? So everything. Okay? That's how you get paid your lawyer's fees. And generally the way this works out, so let's go back to that non-disparagement clause for a moment. Let's say my client hires me to go send an nastygram that says, hey, you need to take down this negative review. Well, I include in that letter, by the way, if you don't take it down and you make me sue you to take it down, guess what? There's an attorney fee clause. I'm going to win, and then you're going to pay my client for all the money that they pay me. And that usually gets people to go, ugh, I should probably take that down. Okay? So that's how these things kind of work together to get people to do what you want them to do. All right, cooperation. So we're done with the main clauses. Now just a couple little nuggets that I kind of like to put in the contract. So I view a cooperation clause kind of like an escape hatch. So this is just, I mean, if someone is just intolerable and you figure that out through the course of maybe even the night of the event, it gives you a way to walk away with no real repercussions contractually, okay? So here's my cooperation clause. Client agrees to cooperate fully and respectfully with planner, and client shall be responsible for ensuring client's guests cooperate fully and respectfully with planner. So not only is the client going to cooperate, they're going to make sure that Uncle John cooperates as well, and he's not a jerk to you, okay? So, super important. Second, in the event client fails to cooperate fully and respectfully, all further obligations of planner are terminated, and you can retain all the payments. Guess what? Same thing as before, non-refundable. That's my money. If you're a jerk, I can walk, I get to keep your money. Thank you very much. Okay? All right. Media release. So, beautiful photographs, videos, all taken at the event. Can you just use those on your website because you feel like it? Generally, no, right? You can't. You need a media release. Now, are people going to sue you all the time, tell you to take down photos or videos from your website? Probably not, but it's probably a good idea just to put a media release in your contract, okay? So, here's an example. Client gives planner the perpetual right to use and authorize others to use. So let's break that down. The perpetual right. You can do it forever. You get to use this forever. And you can let other people use it if you want to. Client and client's guests in attendance, their names, their images, their voices, their likenesses, and any and all media now or hereinafter devised. So great, let's say we come up with holograms in 2030, and that's the way we advertise. You can put grandma at this wedding in a hologram, and people want to hire you. Super awesome. Awesome. And planner may utilize said likeness for any means, included but not limited to advertising, promotional materials, online materials, and other materials. So that ensures that on the back end, you can use these photographs, you can use these videos to make other people want to hire you, okay? All right, just general contract musings, and then I think we're at Q&A. So, in general, this is why it's so important for you to draft a contract that makes sense. And all the things that I talked about today, I mean, if you copy and paste those and put them in a contract, it will be less than 1 page. I promise you, it'll be less than 1 page, okay? And here's why that's important. Because vague, ambiguous, and unclear contract language, it is construed against you because you drafted the contract. So right now, if you're using a contract that doesn't make any sense, if you try to sue someone over it, you will probably lose. If someone sues you over the contract, you will probably lose. And you'll probably lose because if your contract is vague or if certain portions of it conflict with one another, that's your fault, okay? And the courts will construe it against you. So that's why in my mind, 1 page, that's it. Make it super simple. Don't make all this legalese, and that'll give you the best shot at your contract being enforceable in the courts if it needs to go that far, okay? Statute of limitations. So every state has a different statute of limitations. That is just the amount of time that you can sue someone if they breach your contract. In North Carolina, it's 4 years. So just know, if you have a client that's upset with you or what have you, they have a certain period of time to sue you. They might sue you 2 years from now, 3 years from now, depending upon what the statute of limitation is. So just keep in mind what yours is. And then third, you know, hopefully you've never ever had to hire a lawyer over litigating surrounding event contracts or anything like that, but it is super, super expensive. You would think it's cheap. It's not. If you hire good legal representation, and in most states, they actually require, if you are a business, if you're an LLC, a corporation, they require that you hire a lawyer. So you can't walk into court and represent yourself if you're a business. So just keep in mind, lawyers are expensive. If you can resolve some sort of dispute at the outset without going to court, that's probably smart, only because it's so expensive. And if you have a contract that has all this stuff in it, you have good leverage to get something resolved before you ever have to go to court. All right, cool. I think that's all I got. Questions? Any questions? Yeah.
So my name's Andy. I work for a hotel. We have a big company that owns us. So we have a very, very legal contract. I work with a lot of third-party planners, like third-party planners, meeting planners. A lot of them ask for mutual indemnification, and I feel like I have a somewhat decent understanding of it. But where do you see that exposes me as the vendor to risk? Where does that get tricky?
That's a great question. So in general, if you work for a massive company, right? So a lot of my planners or DJs or videographers have contracts with Bank of America. Bank of America is headquartered in Charlotte, right? And Bank of America has its contract, and it's this 400-page tome of a contract, okay? And so the question is, I mean, frankly, you don't have much negotiation power back and forth with Bank of America to go change things, but one thing that I always recommend is reciprocal indemnification. If I represent the DJ that's doing this long-term contract with Bank of America for their events, I would say, okay, Bank of America drafted their contract with a one-way indemnification, right? But it should be reciprocal, meaning everybody indemnifies everybody. And I'll tell you, that's a reasonable request, right, to make it reciprocal. It says, usually, look, if I, the DJ, screw up and you, Bank of America, get sued, then I, the DJ, will step in and defend you, right, if I screw up. But I think it's also fair to say, Bank of America, if you screw up, right? So if there's a big puddle of water and someone slips and falls, and for some reason somebody sues the DJ because I was DJing in front of the puddle of water, right, you, Bank of America, will step in and defend me. And I think that's a reasonable request to make. So reciprocal indemnification, again, I always write my contracts one way because most people don't read them. But if you're in kind of a more sophisticated thing where people are negotiating specific terms back and forth, reciprocal indemnification is completely reasonable and most people negotiate that. Yeah. Yeah. Oh, sorry.
Sorry. Just so, oh, did I?
No, you're good.
So I work for a nonprofit, a museum. So given everything you've talked about here, and a lot of it skewed a little, wedding planner, and that's a great example. But are there any additional points or words of wisdom that you might add for nonprofit entities?
Yeah, so is the museum used as an event venue? Gotcha. So not a lot, right? So most of this language is super appropriate for a venue, okay? So you would have a master service agreement or a venue agreement that says, The package that you get is attachment A, so it's like access to this particular room with seating for this many people for the event on this particular date, and here's how much you're gonna pay, and here's when you're gonna pay it, right? All that reciprocality stuff, all of the indemnification language, all that stuff makes complete sense for your venue agreement, just like it does for a wedding planner. Some of my venue clients like to throw in some additional clauses, but I'll tell you, this is the nuts and bolts of 98%. I don't think you need much more. And I would organize your contract just like that. So your package is on attachment A, your general terms and conditions just on the front page. Okay? All right, awesome. Yeah.
So I'm a photographer, and you mentioned that we are allowed to use their images if we put it in our contract. We also have in our contract, they're not allowed to pass on their photos to Cousin Joe, who's starting their own photography thing.
Yeah.
Is that how you would word it, that they are not allowed, or how would you exactly word it to make sure that they are not passing along our images to someone else to use as their, hey, look at me, I take pictures?
I would say something to the effect of, your company owns the photographs, and before they can transfer them to anybody else, they have to ask your permission.
No.
Right? And then if they don't, and then of course you'll tell them no. Right? So that's what I would do. I would actually phrase it as, you own the photos. Right? So you own all the intellectual property associated with the photos, and if they want to ask you to use them, they can ask you. Other than you giving them permission, they can't use them.
Okay.
That's
Thanks.
Fine. Yeah, sure.
I have a couple of questions.
Yeah, hit me.
So I am part of the government. I am a local government who also does events. Are we allowed to do a non-disparagement clause,
Yeah,
or
sure,
is that you know?
Can the government?
Can the government do that?
No.
Okay. So what other things change if you're talking about a government?
Yeah, that's great. What local government do you work for?
Local government, township.
Okay, gotcha. I have no clue because your state laws, I don't know.
Excellent. All right, we'll skip past that one. I just was charmed by that. I was like, I don't think I can do that.
Yeah, so on the non-disparagement piece, agreed, you can't. But I mean, payment terms and indemnification and all that stuff, you can cram all that in there.
This has been wonderful. Thank you. I'm working on changing my contracts already, so this is fantastic. My clients don't read the contracts. Absolutely not. I always have problems with that. In the moment, my staff who are there on the front line are trying to enforce parts of it. Yeah. Is it worth having clients like initial some of the clauses? Does that help any?
I found no, it doesn't. And a lot of people make a big deal about that. Like some of my clients that come to me that, not trying to be disparaging, they feel like they're really, really sophisticated, and so they have this huge long contract and everyone initials every single page. It's like, well, what does that get you, right? Like, so, and I've got this unique experience where about half my practice is drafting all these contracts, the other half is suing people, right? And so I see how that actually plays out in court, and never once have I stood up and said, well, judge, of course I should win. They initialed every page. It's like, what does a judge care? They signed the last page, who cares, right? So I don't see that the initialing every page or every particular clause, I've found that doesn't matter at all. I think it's not worth it.
That's excellent advice. Thank you. And then can you give an example of the cooperation clause working when a problem occurs during the event? You mentioned that, but I would love to have a specific example.
Yeah, sure.
Thank you.
So, I mean, someone gropes somebody, someone does something super, super inappropriate. And I mean, if you're a planner, and I know in your case, maybe that's not it, maybe it's a venue or whatever. Yeah, venue. Cooperation, I mean, for the venue, the cooperation clause would be, I'm sure you tell people you can only access the grounds during a particular period of time. You can't use illegal substances on the grounds. You can only smoke in designated areas, all that stuff. The cooperation clause kind of fills in the gaps there, and it makes it a little bit more squishy to where if someone is doing something that you don't like, you can say, you're not cooperating, shut it down, right? I mean, that's kind of how those interplay.
Thank you.
Yeah.
So I work for a very, very large company, and the attorneys, a very large department of attorneys, sit right down the hall from us. Yeah. And we are the events team, and they are the legal team for a very large mortgage company. So their understanding of events is minimal. Sure. So when we ask a question, gosh, I wish we had you there, because what we get is just, no, this is what we want, this is how it is, da-da-da-da-da-da. And that's very hard when I have to go back to a client and say, I want to work with you. And I think social, we tend to be able to work around some of this. Just, it's about explaining the contract a little bit more. when we get an equally large, like a Bank of America, and they send us the contract and we're like, no, you sign our contract, we don't sign your contract. Yeah. How do you get to where you are in an understanding with each other? And like, we have the venue, if you want to be here, I guess you'll sign. It's kind of where it ends up going, but.
That is where it ends up going. And
right.
That's where I see it go, because I have some of my larger kind of corporate event planning clients, or I represent a decent amount of like really large DJ companies.
Right.
They have these contracts with Bank of America and Wells Fargo and all this, and they do. The large venues or the large corporate clients come in and say, this is our contract. Would you like to sign it or not?
Right.
And there really isn't a lot of meeting in the middle. And usually my advice to the client, so if any of those clients that you're dealing with, it's tough for you all to sell this to them.
Right.
I'll tell you on the back end, if they have a lawyer, their lawyer is probably telling them you have no negotiation power.
Right.
The only thing maybe you could negotiate is reciprocal indemnification, which this gentleman was talking about. That's usually it.
And our company's like, we'll never mutually indemnify. Yeah. And I'm like, we're stuck here in this, like, nobody's agreeing on anything. But, and their response is, do you get to negotiate your mortgage contract? You don't. Yeah. So why? And I'm like, this is hospitality. Yeah, we don't talk that way.
Moral of the story is lawyers are jerks.
I'm trying to love them, but you seem awesome. Thank you.
No, there's nothing you can do.
Okay.
Yeah.
Sorry, I thought of two more.
Yeah, sure.
I don't know why there isn't a line out the door. It's free legal advice. He usually charges, what, $300 an hour? Come on.
$325. Yeah.
Okay. State of Nevada and other states without dram shop laws. Yeah. Is it still required, do you think, to have a release of liability surrounding alcohol-related incidences, or does the state statute already cover that?
I do belt and suspenders, meaning, so it's fine if it's got a statute. Who cares? Put it in your contract anyway.
Okay.
Right? I mean, I don't think it hurts to put it in there. Yeah, most states have dram shop laws, but yeah, I'd put a specific release for indemnification related to alcohol-related injury. Yeah.
And then the other thing with agreements, so a lot of like event venue agreements, you're saying anticipated attendance for a thing, for an event. The real bolts of it are a venue fee and a food and beverage minimum mostly. Yeah. In the situations where it's not going to happen again, but say we can't, we have to limit capacity of an event. Yeah. Are we still able to enforce our contract, or is that when someone, because there's people that can come and say, well, frustration of purpose, it's supposed to be 200 people. We're saying, well, we never said we guaranteed you a 200-person event. We guaranteed you this ballroom and asked for this minimum.
Yeah, I think being squishy with your language makes sense. I think especially if you have anticipated numbers and someone tries to go after you with frustration of purpose and all that, you've kind of covered that in your contract, right? So what's the question specifically?
So I guess someone had said, I mean, as the venue or the service provider, are we still on a leg to stand on, even if we do get limited again, to say, hey, because there was lots of webinars, and one of the webinars said, hey, as long as you're offering something to solve the problem, a date move for free, or lowering the minimum to accommodate the new guest count, you're in good standing. But a lot of people get really frustrated and say, well, I can't have my event attendance. I mean, where's it just seems like a very gray area.
So if you've got all the clauses that I discussed, then what that allows you to do is whatever you want. If you want to keep the money, keep it. If you want to work with them to change the date, right, then change the date. You could change the date 20 times, right? And I mean, frankly, that's what most of my clients did that use a contract that's very similar, like ones that I've drafted for them. They weren't jerks. When everybody called up and wanted their money back, they said, how about I change the date? How about we just push it back, right? And they said, yeah, that's fine. And so they got to keep the money, and ultimately my clients will perform the services, fine, But if you've got that force majeure language that says, look, if there are governmental shutdown orders or due to the pandemic, I can perform or not perform as I see fit, right? So if you want to limit the total number of people that can show up, and if they don't agree to that, well, I'm so sorry. So sorry, client.
Okay, thank you.
Yeah, sure.
Afternoon.
Yeah.
So I got a few questions. I think my first one kind of encompasses two of the sections of it. Can the person signing a contract, can your client sign away the rights of others?
That's okay. So there's an entire section that I didn't really cover here, which is who signs your client contract, right?
Right.
That's a great question.
For instance, the photos,
Yeah,
you know,
yeah.
if you want to use photos, or even the alcohol part, if someone slips
Sure.
and falls.
Yeah, so especially on the media release, right? It says, client and client's guests release their image, likeness, yada, yada, yada. If, let's say, LeBron James was one of those guests and he decided that he didn't want you to use his image or likeness forever, he would probably have an okay argument to say that you're not allowed to use LeBron James's image and likeness forever, right? But I like to put it in the contract because it pretty much covers everything, and you can point to it and say, this is what the contract says. If someone was going to test that one particular piece of it, who was a guest at an event that you were the host for, and they sued over that, dicey, right?
Well,
Dicey.
I would think that the alcohol part might have a little bit more weight. You know, if a guest claims they're overserved, they fall off the stage or whatever it is, that guest can sue the company directly.
Sure. Oh, yeah. And
Like I said,
remember,
anyone can sue anyone for anything.
for any reason
right.
at any time. That's right.
Mhm.
Yeah.
Another question was, how do you define cooperation in the clause?
Yeah, sure.
If they're not cooperating,
Did
how do you put those parameters on it?
Yeah, did you see how I didn't define cooperation?
Exactly. And another part, you said that you don't want it kind of that loosey-goosey because the judge is going to say, well, you didn't specifically say it.
And that's fair. So remember, the general theory of this contract is you're going to describe what you do very specifically, and everything else you're going to be general. And you're going to be general because that gives you the flexibility to do whatever you want. And so the way I wrote the cooperation clause says, client and their guests, client themselves, they will ensure that themselves and their guests cooperate with you. And if they don't cooperate, you can keep their money in bounds. Well, what does cooperation mean? That is in the eye of the beholder, and you are the beholder, right?
Okay.
So whatever you feel like cooperation is, that's what it is.
And going back to what you mentioned about who's signing the contract, what if the bride and groom are signing the contract, but the parents are paying?
You got it. So that's a great question. So anytime, whoever the hosts are of the event, right? So if it's a bride and groom, they sign the contract. If mom and dad are paying, I make mom and dad sign it too.
Okay.
So the money man or woman, they sign it, and the people who are hosting the event, they sign the contract. And I do that to make sure everybody's locked in. That's right, because if dad's paying it and he didn't sign the contract, you didn't bind dad.
Right.
You know? So yeah.
And
That's a great
just
question.
one more quick thing is, as an attorney, do you accept deposits or retainers? Because I know that went around a lot in NACE last year when people asked for their deposits back. Even if it says non-refundable, the word deposit is still just a, well, you could probably
I think
define it
all
better
that's
than
a
me.
bunch of BS. It doesn't matter what you call it. I don't think it matters what you call it, right? I mean, I just say the event cost is $10,000, right? And you're going to pay me $5,000 up front and the second $5,000 a week before.
It's
Don't
all
call it a
non-refundable.
retainer, don't call it, it's not anything. It's just, here's the amount that you owe me and you're going to pay it to me, right? I wouldn't even engage in a discussion of retainer versus deposit versus whatever else.
Yeah, because I think we all had to deal with that a little bit last year.
Yeah,
Yep.
sure.
All
I
right.
agree.
Thank you.
That's right. Sure, you're welcome. Hey there.
Hi, I have two. The first one is the force majeures. I think for years, we've had them in contracts and things. I work for a university now, and they're super ultra conservative. And we have some clients actually saying that the force majeures are the venue acting in not good faith, that something will happen. But they've been around so long, and I think just because people have had to act on them, we're closed down for events for 6 months. How do you, or what's a good way to sort of tell them that this is legal? It's been legal for years. All of a sudden now it's becoming more. Is there anything to help with that?
Yeah, I mean, one way you could change your force majeure clause a little bit, if you wanted to meet them in the middle, if you wanted to. I mean, if you're a university, maybe it makes sense to take a hard line like Bank of America and say, this is the contract, if you don't like it, I'm sorry, right? If you wanted to meet them in the middle, you could take out some of the stuff that is unrelated to COVID, right? You could take out acts of war. You could take out a bunch of this other stuff.
Okay.
And if your force majeure clause is just related to COVID and pandemics or epidemics, then I think everybody understands, look, COVID may cause this event to change, right? Everybody gets that. And so I don't think that's, are they saying the inclusion of a force majeure clause in and of itself is bad faith?
Well, some are saying that, and some are saying just what you just said. And, legally, we didn't know exactly yet what to.
Yeah,
but
I mean, you could get hyper-specific just related to COVID, right? Call it COVID-19 and all that. But to me, like, if you take out acts of war, what happens if there's a bombing?
I know, right?
Like,
Yeah.
You never know what's going to happen.
Oh my
That's
God.
the whole purpose of the force majeure clause.
Yeah.
And so you can make it hyper-specific to COVID if you wanted to. I've had some clients want that, and I put that in the contract. So I
Okay.
think that's a reasonable solution if you wanted to do it.
Okay. And then the second thing is, do you have, are you going to have copies of your slides or some templates maybe that you'd be offering to us that attended?
Yeah, so I think there are digital copies of this.
Sorry.
Yeah. And if you just, there you go, done. Thank you very much.
Thank you.
Oh, okay, yeah, that's fine. Sure. And I'll hang around at the end if you want to.
Hi, I'll be quick. So I work for a privately owned country club, and we, of course, like I'm sure a lot of people in here, have had people request to push back their date, and we've worked with them and basically said, all right, you've got 6 months to reschedule your date or a year to reschedule your date, and required them to sign a new contract. And my thought was, are we on the right track with that? Should we require them to pay an additional deposit? Should we just notate the initial deposit was paid on this date? And any suggestions on like a kind of a limitation on timing?
Yeah, I mean, so I like having them sign a new agreement. I think that makes sense. I also like, as a part of that new agreement, saying, hey, because of COVID, you want a new date, right? And because you want a new date, this is contract number 2. They sign that, right? Do you need a new deposit? I don't know. If you're out time and money and effort every single time somebody changes a date, I've got venue clients of mine that have a date change fee, right? And the date change fee is a percentage of the overall fee, right? So let's say you charge $10,000 for someone to use your venue, it's 3% of whatever the overall venue charge is. That's what some of my clients do. Now, again, if you put that in there, you can look like an American hero by saying, well, look, we've got this 3% fee, but Carol, I love you as a client. I'm not going to charge you this at all, right? So you can do that with it and then not abide by it, and then you look awesome.
Okay.
You know?
Awesome.
Yeah,
Thank you.
Sure. Thanks. All right. Thanks.
On behalf of everyone, I know me personally, I'm going back and changing my whole contract, so thank you. And on behalf of NACE as well,
Oh,
we want
nice.
to give you this.
Oh, thank you very much.
Appreciate you coming.
Appreciate it. Thanks, everybody. Yeah.